I'm wondering if you can hear me with my headset on. Hello? 1 2 1 2. Seems to work. I don't know. Oh, my cat. God damn it, this cat. So, okay. This came down. Yay. Hi everyone. Good morning. Good morning. Good morning, party people. What are you drinking this morning? I'm having coffee, as usual, and I'm walking around following my cat. So interesting. Piece of legal literature came down that I wanted to talk through with everybody because I think it's important to get out in front of whatever the narrative will be about how frivolous this is, and we know that's coming from parties opposed to facts, due process, shit like that. So coffee, all right. Morning, good morning. Hello, hello, possum friend. Um, let's see here. So let's see. Should we go ahead? And I mean, there's 9 people here. I'm not expecting to get in many more. Oh, coffee, of course. Salutations. Hello, hello. So I did have a chance to kind of just look at a few things, but let me add this, and then we can talk about it. Just chat. So just to give you, kind of ground us in where we what this is in response to. The motion to correct error was filed, whatever, a couple weeks ago, and that was something that was done obviously by the defense team, which countered to the prosecution's sort of narrative around it. It's not, it's part of the process, and it's part of creating an accurate record to ensure that, Mr. Allen, going through the appellate process, has all of the, everything on the record. So it wasn't about publicity. It wasn't about making up stories about, quote, new information. It was about getting everything on the record. Critically, I think, too, when we think about the state's response, which was what this is actually in response to. So the motion to strike is responding to what Nick McClellan filed. Was it last week? I think. So, and here's the thing that I've learned, is that in journalism, and as I'm learning, as with law, you need to bring receipts. So when I go to file a story, I got to make sure I have all my shit lined up. If that's audio from interviews, my notes, my exhibits, literally like photos, whatever, I have to come and bring those things to bear. Otherwise, the story doesn't fucking exist, right? It's the same thing with legal filings. And what Nick McClellan filed was asserting, it was Wackyville, because he was, first of all, it was just, some of it was just demonstrably false, or alternatively, it was willfully misleading. So that brings us to the motion to strike, which is very, very interesting. And so remember, this is another thing too, I want to say up front. There's a lot of things that this is another crossover between law and journalists. Journalists get shit on all the time for being liars. Lawyers, defense attorneys get shit on all the time as being liars. Here's the thing. You put your name on something, you sign and attest to it, whether it's in a byline or on a court filing. They don't lie. They don't lie in these documents because they don't. So I just want to dispel that right now. And I'm sick of people, who I'm talking about. Anyway, so let's chat. here is what we got going on this morning. So in Carroll County, defendants verified motion to strike the state's response to motion to correct error. So defendant Richard Allen by counsel now comes before the court with his verified motion to strike the state's response to motion to correct error response filed on February 4th, 2025. For the reasons that follow, the court should strike the state's response in its entirety from the record of this case. This isn't hyperbole, so let's get that out of the way. That's not hyperbole. This is coming with receipts, right? So this isn't some stunt. This is about rules. This is about the rules of court rules, trial rules, and laws, things like that. So it's not hyperbole. Don't let anybody tell you that, right? Okay. So state's response is unverified and without supporting affidavits asserts numerous facts outside the record in violation of trial rule 59H2. Now, see, I could just stop right there. Unverified, right? Unverified. It smells like laziness or obfuscation to me on the state's part. So this trial rule goes on to say, if a party opposes a motion to correct error made under this subdivision, that party has 15 days after service of the moving party's affidavits in motion in which it files opposing affidavits, citing case law. Motion to correct error, unsupported by affidavits, presents nothing to the court to consider. Okay, so that's basically just setting up, hey, we've got the right to do this, and that's what we're fixing to do. So now we get into the direct response to some of the things that McClellan has been alleging or stated in his response. In particular, on page 2 of the state's response, Mr. McClellan alleges on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that it would not be representing the defendant. Here and attached as State's Exhibit 3. That allegation is based on facts outside the record and unsupported by affidavit verification. On page 7 and 8 of the state's response, Mr. McClellan alleges the defense received the van video and any information pertaining to Ron Logan included in Allen's motion to correct error on January 3rd, 2024. That allegation, Mr. Cleland asserts, is supported by State's Exhibit 7, a, quote, discovery release. These allegations are based on facts outside of the record and unsupported by affidavit or verification of trial rule. It cites it there. So what this is just saying, hey, he's making all these statements without providing any receipts, right? Now we get into some interesting stuff. Okay, so, I mean, it's all interesting, but you know what I mean. Let's see. Page 8, state's response. Mr. McClellan says Rishi Davis was interviewed by law enforcement, which he was, as shown by defendants exhibits 4A, 4B, and 4C. But Mr. McClellan also said Mr. Davis requested a polygraph exam to which he, quote, failed miserably. This was in McClellan's filing. So no exhibit of Mr. Allen says anything about a polygraph examination. These allegations by Mr. McClellan are based on facts outside of the record and unsupported by an affidavit or verification on violation of the trial rule. Again, you can say it, Nick, buddy, all you want, but you have to attach like the thing. You gotta attach the thing, sir. Ricky? Is it announced? Reese. Okay, I don't know. Okay, I'm trying, y'all. Okay. So similarly, on page 8 of the state's response, Mr. McClellan says Ron Logan told Mr. Davis, quote, he removed the cell phone. Okay, this is interesting, right? He removed the cell phone's battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned them. Nothing in any of Mr. Allen's exhibits pertaining to Ron Logan's confessions to Mr. Davis say anything about Logan removing a battery from the phone. Similarly, nothing in Mr. Allen's exhibits pertaining to Ron Logan's confessions to Reese Davis say anything about Logan burning girls' clothes. These allegations by Mr. McClelland are based on facts outside of the record and unsupported by affidavit verification in violation of the trial rule. Now, I want to point out something here before we move on. We all know prison snitches or whatever can be unreliable narrators. I don't think anybody has any illusion to that. Here's the thing. I do not want people to be confused that even if 99% of what Mr. Davis says is absolute codswallop, 1% could make the difference, right? That's the thing. We know that, right? So when you hear people bleating on about failing polygraphs miserably, well, where's the evidence for that? I mean, maybe he did. Shit, I don't know. But you're telling us this without supporting it. So I just want to make that clear. Everybody knows. Nobody. I mean, I'm not relying on Mr. Davis's statement alone. What I do think is interesting is some of the things that were revealed, right? Some of the things that were revealed from Mr. McClelland's statements, and it's pointed out here. You know, where Mr. McClelland says that Mr. Davis, right, in this supposed confession, that quote, he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned them. Where did that come from? Where did that come from? Because as we will go on, and let's see, shall we? Shall we do our first footnote? Shall we? The tip in the Orion database, Defendant's Exhibit 4A, does recite, oh, now this is the weaponization of italics. Here for it, love it. Does recite, Logan told Reese how he burned his clothes in a fire pit and where it was located, emphasis added. See also weaponized italics, in righteous weaponized italics. Defendant's Exhibit 4B at page 3 burned his clothes in the burn pile. So you see what we've done here? And this is why, God damn it, chef's kiss to well-written stuff, right? I mean, my God. Here's what was said, court. Here's what the state is alleging in its filing, for the court to just take my word for it. But here's actually what was said from the Orion database, which is the state's database. Okay. Moving on in the footnote, which is, again, beautiful. But again, nothing anywhere says anything about Logan confessing to taking a battery out of a phone. Remember, we're making a record, folks. While the court might take Mr. McClelland's misstatement of fact about burning of the clothes simply as a mix-up on his part, either Mr. McClelland is making up the allegation about Logan removing a battery from a phone out of whole cloth. Oh, God, I love that too. Whole cloth, which means fucking out of nothing. Or he has access to information about Ron Logan's confessions to Reese Davis that he has not shared with the defense. Ooh, yikes. In either event, there is a reason Trial Rule 59H2 requires affidavits in support of a response to a motion to correct error when that response is based on evidence outside the record. So this is giving a huge benefit of the doubt to the state. And I think that's right. I think that you have to try to, and this is unpopular as hell, but you have to try to extend all courtesies that people are fallible, shit happens. And maybe, just maybe, you know, McClellan did get it messed up. Hang on a second. I got to cough like a motherfucker. Hold on. Okay. That was me. Sorry. Allergies. Anyway, so, but the point is that, you know, McClellan stated and this is why they just need to keep talking, right? Keep talking, keep doing interviews, keep doing filings that provide additional information. Just keep doing that. You're telling on yourself. Okay. So moving on. Also on page 8 of the state's response, Mr. McClellan says, quote, no evidence places Ron Logan at the scene of the murders, end quote. Besides not being true, this allegation by Mr. McClellan is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. Now, again, what is outside the record? Anything that's not supported by an affidavit, right? So you got to remember, and we'll get to it here in a hot second, but there was only one affidavit that came with the state's response to the motion to correct error, and it was a doozy, folks, and we'll get to that part. Moving on. On page 9 of the state's response, Mr. McClellan says Sergeant Cecil was able to observe photos of the phone when it was found, herein attached to state's exhibits 9, 10, and 11. Footnote 2. Oh, okay. Oh my God. Okay. In addition to not saying whether or not, we're going to go back to footnote 2. In addition to not saying whether Sergeant Cecil actually observed those photographs, this allegation by Mr. McClellan is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. Now, let's go back to footnote 2, because here, and I swear to God, if I hear anybody reporting that this is snark or that this is somehow, you know, underhanded bullshit or a slight against the prosecution, well, I mean, it kind of is, but releasing photos, right? Releasing photos of the crime scene where the girl's phone was found. Mr. McClellan did that. So we got footnote 2. The court might want to consider whether to hold Mr. McClellan in direct criminal contempt for publicly filing crime scene photographs the court ordered sealed at Mr. McClellan's own request. Now, we get to some case law, which is quoted here in the footnote, quote, where, as here, the court has firsthand and immediate knowledge of facts demonstrating a clear disregard for its authority, which threatens to undermine the integrity of the judicial process, summary proceedings for direct criminal contempt are available. See also the above at 1296. The power of Indiana courts to summarily punish for direct criminal contempt while specified by statute rests upon the common law. It is inherent in the courts, end quote. Alternatively, so there's, or in other words, if you need another little bit, Judge, alternatively, under Indiana Code squiggly S, which is subsection 34-47-3-1 and 34-47-3-5. The court might consider issuing a rule to show cause while Mr. McClellan should not be held in indirect criminal contempt for his willful violation of an order of this court. I want to spend a moment living in this space. It matters. So I want hearken back to the trial when I don't know if it was ISP or deputies, pursued a person who ended up being of a University of, I almost said Illinois, University of Indiana student, who was behind the van carrying the jurors. And that phone, they pulled her over, uh, apparently without cause, took her phone without, you know, I mean, just took her phone, um, checked it out, dug through it a bit, and gave it back, right? That's extrajudicial bullshit. In addition, when 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 Mr. when the leak happened, right? So when I'm not talking about Murder Sheets leak in 2022. I'm talking about the crime scene leak. The threats that came out of the mouths of Holman at Grissom, is it Grissom Air Force Base? Uh, that he would get the judge on the phone and that he could, basically throw him in the clink for all, shit on his phone. That there was much bluster uh, coming out of the court that basically said, I'm going to, if we find people having these, we're going to track them down and drag their asses into court, right? So when listening to other coverage, and you know what, take my shit with a grain of salt, but here's my perspective, just from a grumpy old journalist, is that this matters. And it matters because Nick McClellan filed to have these things sealed. So what does it mean if he violates the law, right? The law would be that in direct violation of a court order that he requested. This is a problem. This is emblematic of a problem. The state doesn't get to do whatever the hell it wants to do. It just doesn't. And I'm sure that it'll be all sorts of excuse making. Oh, it was just the phone. It was just the. I'm sorry. I'm sorry. No, it's not one law for thee and the other for me. And they need to be held to account. And this is absolutely proper to bring up. And you know what? It's separate and apart from all the bullshit contempt that was pulled on the defense, which I don't know. Anyway, so that's my thoughts. What do you guys think? Um, uh, 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 yeah. So while I do think that it is rich, right? We all know that this is absolutely, to me, this is a response grounded in really good law, So when people try to say it's just the defense doing this and that, no, make Nick do his fucking job. Jesus Christ. Okay. I just, you know what? Oh God, I can't. I just hate sloppy work. Okay, on page 10 of the state's response, in subparagraph 4.L, Mr. McClellan says, quote, there is nothing in the logs, reports, or extractions that would indicate whether or not a phone had some kind of water damage because that kind of damage is not registered in the logs, reports, or extractions of the phone. Whether or not there was water damage can only be determined by physically examining the phone, end quote. Mr. McClellan is not an expert and attempts here to testify as if he were one. Now, we have seen this. If anybody watches Karen Reed, we have seen this. This is a thing, right? This is appropriate to point out. Mr. McClellan is not an expert. The same thing has been successfully argued by His Royal Highness, Mr. Alessi, against Mr. Brennan for spinning yarns about factiness and expertise. Mr. McClelland is not an expert, and he attempts here to testify as if he were one. And this is important too. This pleading is not his first attempt, right? So these are court documents, people. Jesus Christ. Every single allegation of this subparagraph quoted above is based on facts outside of the record and unsupported by affidavits and verification of the trial rule 59H2. The allegations, right. All the allegations above, based on facts outside the record and unsupported by the affidavits or verification, are crucial to the state's response because the absence of supporting affidavits or verifications by Mr. McClelland violates the trial rule, and state's response should be stricken in its entirety from the record of this case. Right? So you file a sheet of paper with all of these allegations on it, but don't file. Like, why didn't you have Mr. Cecil whip up an affidavit to attach to this, Nicholas? Why? I mean, that would have been easy, right? I mean, I'm sure you could have gotten a hold of him to sign something. Why? If there's a polygraph, throw it in. What's the harm? But this is what happens when the state gets to do whatever the fuck they want. It's asinine. And it's wrong. I mean, it's not even just asinine, it's wrong. This is the hyper-local of fundamental rights afforded to everybody. And the state is playing fast and loose, and they have been getting away with it because the defense has been so marginalized as to have been incompetent liars, right? It's important. Okay, anyway. Whew, getting hot. Okay, where the fuck was I? Okay, the phones. Oh, here we go. So this is the next interesting part. So we do now get to the part where Nick, in his response to the motion to correct error, did decide to file an affidavit. And thank you, Nick. Thank you. Because again, keep talking. In addition to alleging facts outside the record of this case without supporting affidavits or verifications of the facts in his own motion, Mr. McClelland repeatedly misstates the law and therefore misleads the court. On page 2 of the state's response, Mr. McClelland says the statute governing safekeeping orders in Indiana Code 35-33-11-1, quote, does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. He repeats the assertion on page 3, saying Judge Diener was, quote, within the jurisdiction, end quote, of the statute, quote, to make a ruling on the safekeeping motion without a hearing. That's not what it says, right? That's not what 35-33-11-1 says. The court can. It doesn't say shall, right? We know shall is that magic word. Shall is that word, right? He is within the jurisdiction to make a ruling on the safekeeping motion without a hearing. That's not what it says. Listen, I'm happy to be wrong. I'm not a goddamn lawyer. I mean, and if anyone is, I'm happy to listen, but I don't, okay. Up, we go on. But this cannot be so, because as set out in Mr. Allen's verified motion to correct error on page 6 under the next section, which is also part of the safekeeping. So I looked into this extensively when the motion to correct error came out, because I couldn't get past this, what I feel is like it's going to be an interesting argument about the safekeeping order as a critical stage of the trial. And but that's why we need hearings. So I looked into this particular part of the code pretty extensively. And the thing is, it doesn't, there's actually three subsections, I think, to this section that McClellan sort of cherry picks here. So this filing goes on to point out that there's more to it than that, court. But this cannot be so. As set out in Mr. Allen's verified motion to correct error on page 6 under the next section, Indiana Code 353311-2, right? So that's subsection 2. Mr. Allen has an absolute right to refuse the transfer to the Department of Corrections because then Sheriff Lesenby had only alleged the safekeeping request was to protect Mr. Allen's personal safety. How could Mr. Allen have exercised that statutory right if the court could make factual findings based off then Sheriff Lesenby's motion alone? We've got another footnote coming up. He could not have, of course. And Mr. McClellan's, quote, interpretation, for lack of a better word, of the statute is completely unsupportable. Shall we go to the footnotes? Shall we? Okay. We shall. Footnote 3. The state's response does not explain how there was even any evidence before Judge Diener. And this is important. Like, I'm reading this very snottily, but I'm here to tell you I've earned being a snot because I'm just old and grumpy and I've seen too much of this shit. But this is serious shit, folks. This is serious. So all of these things, all of the points that are being made here in these footnotes are serious. And it has to do directly with that critical stage where Mr. Allen was denied access to counsel, even though he had counsel. Okay? So 3, this is footnote 3. The state's response does not explain how there was even any evidence before the Judge Diener from which he could make a factual finding without a hearing to support his safekeeping order because then Sheriff Lesenby's motion was unverified. Again, it matters. It matters that it was unverified. Again, you watch people that watch trials, people that watch shit gets thrown out. I'm not saying entire cases, but if you don't go through and follow the rules of trial, the local rules, the court rules, it matters just as much as the code, chapter, verse, letter of the law. So let's make sure we get that straight. It was unverified, right? So this is back again when Mr. Allen was arrested, going back to 2022. So then Sheriff Lesenby filed a safekeeping order that was unverified without making factual findings. And I think everybody probably, I'm not going to pull that up and go back through it, but I think we've all seen it. Footnote 4. At pages 2 and 3 of the response, meaning from Nick McClellan to the motion to correct error, without denying that he knew Mr. Allen was represented by Brett Gibson, and that's important, without denying he knew Mr. Allen was represented by Brett Gibson. Mr. McClellan attempts to make much of Mr. Gibson not having filed an appearance for Mr. Allen. On page 3, for example, the state's response says, quote, as of the filing of the motion of safekeeping, the defendant did not have an attorney of record, end quote. This complaint should strike the court as odd because Mr. McClellan appeared at Mr. Allen's initial hearing on October 28, 2022, and filed the state's verified request to prohibit access to court record the same day, with no service of that motion on anyone, of course, even though he knew Mr. Allen was represented by Mr. Gibson. And on November 22nd, 2022, Mr. McClellan both filed his request for what became known as the quote gag order and appeared for the state at the hearing on his request to prohibit public access to a court record. So I think what you're saying here is that Nick, you can't keep all your balls in the air. But Mr. McClellan did not file his own appearance. Now, this part I do find fascinating and arguably a little snarky on the defense's part, but but Mr. McClellan did not file his own appearance in this case until the next day, November 23rd, 2022, almost a month after he initiated the case. It is apparently enough that everyone knew for a month that Mr. McClellan represented the state without his having an appearance on file, but it is insufficient for Mr. McClellan, then Sheriff Lesenby, at the very least, to have known that Mr. Allen was represented by Mr. Gibson, regardless of Mr. Gibson's not having filed an appearance. A somewhat worn saying about glass houses should come to mind. Oof, okay, that's a little far, right? That's some far. So, I mean, he's a prosecutor, right? I mean, we know he's representing the state, but listen, I can't find fault with really wanting to throw that in, because I think that it's just building on the mounds of hypocrisy here, right? The mounds of hypocrisy. And just to kind of make sure everybody remembers where this was at, and I think that we're going to get into it here in this. Oh God, and I'm only on page 5. That Mr. Allen was arrested. His wife hired an attorney, paid him $5,000. In the motion to correct error, there was affidavits, there were literal receipts, there was information filed by then Attorney Gibson. There was all these emails that were put into evidence, as you're supposed to do. So, and I believe that maybe it was in one of the defenses. Maybe you guys know. So, oh God, I lost my mind. Hang on. What was I saying? It was something important. It was something major. Damn it. Motion wasn't verified. Cronic. Ugh. Could somebody read my mind really quickly and tell me what I was thinking? Oh, I do think, okay, so this is what I want chat. All you people that are here. Hi. Is that I believe that in when the trial was ended and the defense started speaking, did they not talk about, and I could be making this up, but I thought that they had said, and maybe this was in a filing as well, that Mr. Gibson, the attorney that had been retained by the Allens, had been in phone contact with both the court, meaning Nick McClellan, the state, and the jail, and could not locate Mr. Allen because they had put him under a pseudonym. Is that right? Am I getting that right? Somebody will know. Hi, lead with love. Yeah, and so this part here, I'll allow it. It's very telling that Nick entirely avoided Mr. Gibson's start time as a lawyer and focused on its ending. Yeah, I mean, I thought that too, because it's almost like physics, right? Isn't it like some sort of science where, something doesn't, how can something have an end if it has no beginning? Right? How can Mr. Gibson's tenure come to a prompt close without ever having been noticed? It's just stupid. Um, yeah, that's what I recall too. Well, he was under an alias. He was placed under an alias. So yeah. Um, um, yeah. Uh, let's see. All right. So anyway, let's go back to this, right? On pages 5 and 6 of the state's response, Mr. McClellan says the presumption of prejudice from you. I okay. I did go on a little bit of a tirade about chronic versus chronic, and Mr. McClellan's misspellings, and that was snotty, but what do I care? On pages 5 and 6 of the state's response, Mr. McClellan says the presumption of prejudice from U.S. v. Cronic, 1984, is, quote, is only applied in cases of non-representation throughout the entire case. Smith v. Brown, citing this case, end quote, right? Apparently, Mr. McClellan is unacquainted with the footnote 25 of Cronic, which unambiguously, that means without ambiguity, right? Says, quote, the court has uniformly found constitutional error without showing of prejudice when counsel was either totally absent or prevented from assisting the accused during a critical stage of the proceeding. In Smith v. Brown, the Seventh Circuit case Mr. McClellan relies upon says nothing different. In Cronic, the court explained that presuming prejudice would be appropriate in the face of a complete denial of counsel or denied at a critical stage of the litigation, end quote, citing Smith. So that, yeah, right? So the the thing that's going to come up here, the law doesn't seem debatable. The law is not debatable. What I'm sorry, the law is not. Yeah, the law is not debatable. What is up for argument in a hearing is whether or not the safekeeping was a critical stage. That's what's going to be argued. That's what needs to be argued. Because other cases have found that, lineups um, have been critical stages. There's one case that I looked up a while back from my home state in Iowa, and I actually was just looking at it this morning, but it established that um, that the adversarial process attaches, and that can be, went upon arrest, depending on what the situationally. And in the case in Iowa, it was awful. It was a murder. It's a mentally ill guy. And this is going back into the 70s, I think. But he was eventually arrested in Minneapolis. He spoke to an attorney in Des Moines, said he wanted to make a full admission upon returning to Des Moines, being transported back, and wanting to speak to his lawyer. Then he wanted to make a full confession. However, in that case, I don't know if it must have been ISP or maybe it was whatever it was, went up to grab him from Minneapolis. And during the 3.5 hour drive from Minneapolis to Des Moines, proceeded, even though they knew that he had invoked and spoken with an attorney, proceeded to get him to confess without his lawyer present. Now, was the guy still guilty? You bet. Was it appealed and the appeal was granted based on that bullshit? Yeah, it was. So I gotta find the name of that goddamn case because now I'm saying shit and I'm just making it up. One moment. Talk amongst yourselves. Dude. Or hum. Let me see. Here we go. Mm-mm-mm. Mm-hmm. It is called. God damn it. So there's a Seventh Circuit one that's Garcia versus Hep. that was recent, 2023, that found out a lineup was a critical stage. Um, mm, mm, mm. Man, you might have to just take my word for it. I can't find it. Damn it. I have my little notebook. Mm, Hep. No. Ah, here it is. Corey v. Iowa, 1968. This was a little different in that it was a confrontation clause, but it was about, I think that one of the principles set out in that one was that it was when that adversarial process starts. So, I mean, I think this all has to be taken, and this is why there needs to be an argument, right? There needs to be an argument in court. Okay. And we said this, right. We went through all the footnotes. Okay. So we were at the point where he was citing Smith and quote Cronic. It really is not, yeah. So it's really not debatable that Mr. McLeland has at best misunderstood Cronic. Cronic. Quote, our recent cases make clear, contrary to the Court of Appeals conclusions below, denial of counsel at any critical stage of a criminal prosecution is per se constitutional error, end quote. Emphasis added, citing Thomas v. Kemp, 1986. On page 6 of the state's response, Mr. McLeland calls the van video, Defendant's Exhibit 3A, quote, at best impeachable, oh my God, and the weaponization of the sick. Oh, grammar, yes. See, this is where the world of words and law come together. Let's see. Okay. It's not even the weaponization. It's just like, come on, man. I know we're all busy, but you didn't even, you know, you don't even have any exhibits. You could have taken some time to comb through your filing. At best, impeachable evidence. That, end quote. That is not so. Agent Pohl's testimony about prior inconsistent statement by Brad Weber would have been, quote, merely impeaching. The van video is substantive evidence of when Brad Weber arrived home in his van. See, for example, Pritchard v. State, Indiana Court of Appeals, 2004. Under the, quote, silent witness theory, video recordings and photographic evidence may be admitted as substantive evidence, according to Carter v. State. 2011. So basically it's just saying, Nick, this isn't impeachment evidence against Weber. And nobody's alleging Mr. Weber was involved in this in any way. As far as the murders of the girls go, this is about the state's timeline. It's not just impeachment. It's about disproving the entire theory of the interruption of the crime. So it's not just impeachment. It's substantive. More importantly, on page 6 of the state's response, Mr. McLeland erroneously asserts that a motion to correct error, quote, only applies to newly discovered evidence, end quote. Actually, some of this I have, actually, Trial Rule 59H, by its own terms, provides for motions to correct error, quote, based upon evidence outside the record, end quote. The rule says nothing about newly discovered evidence. Defense Exhibit 3A, the van video, is evidence outside the record, and Mr. McClellan has no answer to Mr. Allen's claim under NAPU v. Illinois. And again, so this is something else that there was in the motion to correct error, there was this NAPU claim, and Nick McClellan didn't respond to that at all. Didn't even answer that point. So let's see what we got in the footnotes here. So footnote 5 is about the substantive. Okay. So footnote 5. Also on page 6, Mr. McClellan says defendant exhibit 3A, the van video, quote, is in the form of a YouTube. Oh boy. Here we go. Here comes the thunder, y'all. Isn't this what Michael Osbrook destroyed his entire reputation over? Was a YouTube link? I mean, maybe, right? Wasn't there much hay made of this by the, yeah. Excuse me. Also on page 6, Mr. McClellan says defendant exhibit 3A, the van video, quote, is in the form of a YouTube link that is not identified as an item of evidence by an Indiana State Police number and therefore is an improper submission for consideration by the court. I need to stop here and say something very explicitly to my friends across the aisle, that taking that piece of garbage that was Nick McClellan's response to the motion to correct error as some sort of thing written from on the high are full of shit, because that thing was trash. And this motion to strike, it just fucking proves it. Because the thing is that anybody that has been, we know that flash drives were filed. Nick knows that flash drives were filed. Murder Sheet knows that they were filed. I'm going to need these people to stop. I am going to need these people to stop with the bullshit, because it's not journalism. Sure shit ain't lawyering. So let's get that clear. God, I'm sick of this shit. They laughed and laughed and laughed at that crazy old Michael Osbrook. Okay, give me a fucking break. So, listen. These people, oh my God. I had something else completely planned. But I just, I got concerned, y'all. I got concerned. Anyway, getting back to this, getting off my silly soapbox. But I will say that I did reach out to Kevin Greenlee via email and phone. I left him a pretty detailed message about some things I was interested in discussing with him. And I've not gotten any responses. But I actually am interested in hearing both sides. Seriously. I would absolutely talk to them. But they don't want to, apparently. I don't know. I know that I can come on like the mayor's wife sometimes, but when it comes down to doing like interviews and shit, I don't know. You guys, whatever. Anyway, okay. Also on page 6, Mr. McClellan says Defense Exhibit 3A, the van video is in the form of YouTube link. Okay, not police number, blah, blah, blah. So he goes on citing Nick's, harumping and we're the state, you're improper, blah, blah, blah. Defense is terrible. Defense lies. Defense takes courses in law school to lie. They don't. In fact, as Mr. McClelland must weaponization of italics appropriately wielded. Must know. Mr. Allen properly filed the video file that the defendant's Exhibit 3A with a court on a thumb drive. Mr. Allen also properly served the state with the exhibit in the same way. The web link was provided in Mr. Allen's motion to correct error simply for the ease of viewing by the parties in the courts. And Mr. Allen is unaware of any requirements that his exhibits be identified by an Indiana State Police number, especially when the video recording was provided to the event, again, as Mr. McClelland must know, without such a number. I think that, God, I mean, it's just, I mean, y'all, right? It's like just fucking what the shit. I, are y'all still with me? This is like, it's infuriating. It's infuriating because of the way that this has been, and I go back to this at the end of the day, I'm having a lot of fun reading this because I enjoy this kind of rebuttal, which is based in fact. But a man's life is at stake. 2 little girls were murdered. And the state has unleashed, since the beginning, an onslaught of abject fuckery. And they continue to do so with their well-informed de facto mouthpieces. And I think it's a testament to how important it is to support local journalists to do investigative work. Because when all of the information is vested in one compromised, I would say, in my opinion, at this point, outlet, you get bullshit. You get window dressing. And it's just disgusting because this is fundamental to all of us. It just fucking is. God damn. Okay, moving on. Sorry. Everybody okay? Want me to speed up? We can just run right through this. Up to y'all. I need to go adult. Go adult. Do it. Do it. Okay. And again, I'm not even broaching the guilt, innocence stuff here. Like, again, and I've said this before, and I'll say it again. This can be viewed objectively. It's gutting that it's happening, and it's gutting knowing what we know about what I believe was a miscarriage of justice and, yeah, due process, gang, right? So it can be viewed from an objective standpoint through filing by filing, in my opinion. And from where I sit, right? As a journalist, not a lawyer, word lady. Let's see here. So this is back to the NAPU claim in which the state did not respond. Defendant's exhibit, let's start here. 3A, The van video is evidence outside the record. Mr. McClellan has no answer to Mr. Allen's claim under NAPU. Okay, so he didn't respond to that. 1959. That from the van video in his possession, one, Mr. McClellan knew or should have known that Brad Weber's testimony, critical to the state's case as presented to the jury, that he arrived home in his van at or about 2:30 p.m. on February 13th, 2017, before LG's cell phone stopped moving at 2:32 p.m. was false, and two, Mr. McClellan did nothing to correct Mr. Weber's testimony. Now, here comes the law. NAPU 360 US at 269, a conviction must fall, quote, when the state, although not soliciting false information or false evidence. So again, let's get clear, although not soliciting false evidence. So we're not saying they were asking for it or they coerced anything. When the state, although not soliciting false evidence, allows it to go uncorrected when it appears, end quote, citation submitted. See also TVAC v. Hardison, Ninth Circuit, 2011, quote, it is irrelevant whether the defense knew about the false testimony and failed to object or cross-examine. Okay, so here we're getting out in front of it, right? This is getting out in front of it because there was, quote, it is irrelevant whether the defense knew about the false testimony and failed to object or cross-examine the witness, because defendants cannot waive the freestanding, oh God, this is beautiful. Hang on a second, I gotta sit. I was standing up for a second. Because a defendant cannot waive the freestanding ethical and constitutional obligation of the prosecutor as a representative of the government to protect the integrity of the court and the criminal justice system. Let's hear it. Yay! Yay! That's the point. Do not be fooled. It's on the state, you know? It's on the state. So when people say, well, why didn't the defense do this? And why didn't the defense put in that? Some of that certainly is down to having so many motions and limiting go against them and all this other shit. But, it's also down to the fact that the state has responsibilities here. The state has responsibilities, and it's been laid out here in the NAPU claim that was in the motion to correct error about substantive evidence of the van video. So the argument that there needs to be a hearing, it needs to happen, and it needs to be public, because there is so much shit in here, and it's all important. This is all important. It's important to, God forbid I ever get hauled into the clink, because, woof, I want to be able to have my rights protected. And whether or not you believe Richard Allen did it or didn't, it fucking matters how we get to a point. And that is on the state. So anyway, if anybody is forgetting, or if anybody listens to that terrible, terrible podcast by the prosecutors, just remember the burden's on them. Yeah, I saw it. Cleaned up, which I think this is cute. So cleaned up, something was cleaned up. Nice. Okay, everything above About Defendant's Exhibit 3A, the van video, applies equally to Defendant's Exhibit 3E, the FBI subject information sheet from Brad Weber, which shows Mr. Weber's cell phone first began pinging at his family house at 2:50 p.m. on February 13th, 2017. On page 7 of the state's response, Mr. McClellan says the subject information sheet for Mr. Weber is not newly discovered as evidence and, quote, at best, impeachable weaponization of sick, which is great. Impeachable evidence. Defendant's Exhibit 3E is substantive evidence of when Mr. Weber returned home. This is, God. I mean, at what point do you just, oh, God. Substantive evidence. I can't. I mean, of when Mr. Weber returned home, right? Which is what basically the entire van situation is resting on. Substantive. Moving on. Began pinging at his family's house at 2:50 p.m. on February 13, 2017. On page 7 of the response, Mr. McClellan says the subject information sheet for Mr. Weber is not newly discovered. It's impeachable evidence. Defense Exhibit 3E is substantive evidence of when Mr. Weber returned home. You idiot. I'm adding that. Didn't say that. I said that because, my God. But again, this is all record, right? Mr. Weber returned home in his van, and because it was the state's possession, Mr. McClellan either knew or should have known. And again, because Weber was going to testify, right? So conceivably, in prep, Mr. McClellan might have come across, holy shit, this doesn't line up. I've got to notify the defense, right? Because again, representative of the government to protect the integrity of the court, the ethical and constitutional obligation. I know the Constitution is taking a fucking beating right now, but Mr. McClellan either knew or should have known Mr. Weber's testimony that he returned home about 2:30 p.m. was false. And as with the van video, Mr. McClellan did nothing to correct Mr. Weber's false testimony. See footnote 6. Mr. McClellan seems to be under the misimpression that all, again, his evidence is substantive, while contradictory evidence presented by the defense is merely impeachable. Sick. This is of a piece with, I don't know what this means. This is probably a typo. Is it a typo? This is of a piece with his idea, the actual cell phone data showing headphones were plugged into and unplugged from LG's cell phone hours after 2:32 p.m. indicates that data was caused by dirt or water damage, all because the data would otherwise disprove the entire case as he presented, and everyone is to assume that the case must have accurately portrayed what happened. See the state's response at page 9, subparagraph 4J. Oh. Finally, the one affidavit Mr. McClellan, oh, here we go. Okay. Buckle up, buttercups. Click. Finally, the one affidavit Mr. McClellan does have supporting the state's response to the state's Exhibit 5, executed by Tobe Lesenby. The problem with that is Lesenby's affidavit directly contradicts at least twice his sworn testimony at the safekeeping hearing held on June 15, 2023. First, in his affidavit, Lesenby says that Mr. Allen was transferred to the White County Jail on October 28, 2022 because of overcrowding at the Carroll County Jail. States Exhibit 5, paragraph 4. At the safekeeping hearing, in June of 2023, Lesenby explained Mr. Allen's transfer to the White County Jail as follows. This is from the transcript. Question. And so tell the court what arrangements you made to have him placed in White County. Answer. Just a matter of simply having direct communication with Sheriff Bill Brooks and explaining my concerns over potential safety and security of our facility and ask him if he could temporarily hold Mr. Allen for us. Question. Okay. And were you confident that Mr. Brooks and his facility were adequate to hold him on a temporary basis? Answer. At that time, yes. There is not a word about overcrowding at the Carroll County Jail being a reason for Mr. Allen's transfer to White County Jail. So again, keep filing things. And the one affidavit you do file runs counter to the other thing that you filed and to the other testimony that was given. I mean, thoughts? Anybody? Anybody? Ooh. So basically here what's being alleged now is that you know, that when there was finally the post-transfer hearing held, which was already after the damage was done in what is this, June 2023, they were still saying that the potential safety and security of our facility, right? They didn't say that, man, we were just full up of crackheads and really had to, had to make some space. But up here, let's see, what does it say? Can't remember. What did he say? Didn't he say that? Yeah, sworn testimony. Yeah. Overcrowding, right? We're just gonna, how about blue? Let's go with blue. No, that doesn't work. Sorry, guys. Overcrowding. Doesn't say that here. In this affidavit, Lesenby also says that Judge Diener, quote, at no time gave me legal advice on the motion pertaining to safekeeping. States Exhibit 7 at paragraph 7. This is again the one affidavit that he does have, McClellan does have, supporting the state's response. None of the other stuff. None of the other things presented were the cell phone, where all the claiming of facts not in evidence that could have been obtained through talking to the experts that he had utilized in the trial. The one he does file is like, thank you, sir. Thank you. And then it gets even better, right? I mean, this is Jesus, Mary, and Joseph, and all the saints. All of them. In his affidavit, Lesenby also says that Judge Diener at no time gave me legal advice on the motion pertaining to safekeeping. States Exhibit 7 at paragraph 7. In the first instance, Lesenby is not competent to say whether Judge Diener gave him legal advice. And that's true. I mean, he's not a lawyer. He doesn't know what the fuck, That's on Diener. Diener should, that's on Diener, right? It's not on Lesenby. So for that, sure, he can be forgiven. It's on Diener. Doesn't matter. It's the state. In the second, Lesenby unambiguously said Judge Diener adjusted the language in Lesenby's safekeeping motion. Again, let's roll the beautiful bean footage, shall we? Shall we? From the transcript. Cue. Question. All right. And this is the motion that I've just alluded to that was filed by you, signed by you, and filed back in November of 2022. Safekeeping motion, remember? Yes, sir. Answer. Listen to me. Question. Did you draft this motion yourself? Answer. Mrs. Tobe. Actually, I had presented a similar motion to request, I should say, to the court. And as I recall, the court had actually come up or provided this particular document. Holy shit. What? I actually didn't, I hadn't read that part. I didn't realize. So help me understand here. Wait a minute. Am I reading this right? One moment. Presented a similar motion to request. The court actually come up with or provided this particular document. So here he's saying that, yeah, you know, I wrote something up. I sent a little note, and Judge Diener just did all the footwork for me. And then the question then, now I assume this is from Nick, right? Or whoever the hell's doing this. Realizing the catastrophe of what Mr. Lesenby has just said, seeks to clarify. Okay, so let me see if I can ask you a more direct question. Did you prepare that motion at your office on a computer, essentially? I prepared a similar motion to this. Again, the wording was adjusted by the court. Oh, shit. I mean, in my head, this is what I'm seeing. I'm seeing raised eyebrows from the state at Lesenby on the stand saying, let me back this up and ask you again. I'm not signaling to you, but you're going to notice from the tenor of my pitch that maybe you should rethink how you've just said that Judge Diener sent you this motion. And Tobe, bless his heart, says, yeah, I prepared something similar, but yeah, the wording adjusted by the court. So again, it's like, what? So the court gave it to me. No, actually, I repenned it on my computer. But yeah, the court, yeah, in the end. What the shit? I mean, it's like, mwah. I mean, and the thing is that I am laughing, but the fact that this catastrophe of a process was allowed to unfold, a state and a judge who just, what is it? Falling back on Miss Andrea Burkhart's. I've seen some bad judging, but this is some shit. And I don't know bad judging. I know what it smells like. I assume Andrea is correct, as she was a public defender for a while, right? Or for however long. Sure, she's seen her share. When people actually are lawyers, trial lawyers, criminal trial lawyers, talking about law, that's when we listen. Wow. Wow. Tobe. Oh, by the way, head on over to Murder Sheet after this and listen to, yep, Chief Deputy Tobe Lesenby. They just interviewed him. What timing? What timing? That's great. So everybody head on over there after this. No. Oh, why come? I just think I think it's a, it's, I know. I joke. But isn't it something? Isn't it interesting? And I'm gonna, okay, let me finish this because God damn it, my cat, and you guys know about my cat by now. And reviewing and adjusting the wording of a motion. Okay, leaving aside, okay, Judge Diener also, oh my God, wait a minute. Okay. Judge Diener also asked Lesenby to sign the safekeeping motion, which Lesenby did. Transcript at 12, right? Okay. Leaving aside the improv, let's just set the ex parte over here, shall we? We should do that. Should we have an ex parte? Oh, God. Leaving aside the improper ex parte communications between Judge Diener and Lesenby, quote, adjusting the wording of a motion to be filed in this court and on which he should be ruling, obviously constituted both reviewing and drafting a document, which the Indiana Judicial Conduct Rule 3.10 prohibits, except when done for family members. And reviewing and adjusting the wording of a motion is most fundamentally the giving of legal advice, which Rule 3.10 also prohibits. See in regards to Hill, Indiana, 2011. The respondent admits the commission's allegations that his letter advised the couple on the legality and effectiveness of the documents he had refused. This constitutes the practice of law by giving legal advice. I mean, so KO, yes. And see, I'm going to tell you, like my brain, I think I've mentioned I'm autistic as fuck. So my brain thinks in pictures. And so when I see what happened between Tobe, Nick, and what's Diener's first name? We'll just call him Diener. They're all sitting in an old-timey building in the middle of a small town. And Judge Diener is sweating his ass off. Nick is always sweating because he's sweating out the, sweating with the oldies. And Tobe is just standing there like, I don't know what I'm doing here. Judge Diener signs all this shit, has his motion to recuse, and jumps out the back window into a fucking car and drives off into the sunset because he knows that this is a massive fucking problem. It's just a picture I have in my head. Just pictures. I mean, yeah. Okay. Mr. McClellan solicited then from Lesenby an affidavit saying Judge Diener. So we're back to what McClellan did decide to include as an affidavit in his response to the motion to correct error. Mr. McClellan solicited then from Lesenby an affidavit saying Judge Diener had not given Lesenby legal advice when Mr. McClellan knew or should have known that simply was not true. It is not all that different from letting Brad Weber's false testimony go uncorrected. It matters, right? It matters. I mean, people should be pissed that they are paying these salaries without any transparency. The defense is doing their job. The state has not, and Rick Allen is sitting in fucking Westville. And that, and the injustice in that runs across, it transcends victims and whatever. It's not, the rule of law should be accessible, it should be understandable, and there's this the finality of proceedings. That's a big thing in law. There's no finality here. This does not feel in any way, shape, or form like a safe conviction, does it? And I'm not saying it should be. Trust me. But what finality is here? You did your job. This is This is just going to end up in so much more suffering in that community. And you know who it's on? Nick, Tobe, Holman. It's on the state. It is not on the defense. And it's on the killer, no matter who you think that is. But I am talking about the process, the trial. And because they fucked this up so much, we're going to have to see this come back again and again and again. And if people don't care about prisoners' rights or whatever, or even let's just say nobody gives a shit about any of that. What about taxpayer dollars? Don't people get real grumpy about that? I mean, am I the only person that is interested in where the fucking government is spending your money? Jesus Christ. Ugh. Gross. This makes me, mm-mm. Okay, let's see this. This is why I have Rosie issues. Diener's office and Diener invited him to take the case. Oh, I don't know. I didn't know that. I don't know that to be a fact. But you know, I'm not saying you're not telling the truth, Passenger 33. I'm just saying I don't know that. Let's see. Okay. In some, in violation of trial rule 59H2, the crucial facts on which the state's response depends are outside the record and unsupported by affidavit or even verification of the response itself by Mr. McClellan. The state's response also pervasively misstates the law and therefore misleads the court. I'm going to stop here and remind you, at one point during the proceedings, the defense had to go back to Judge Gull and say, hey, when you issue a denial without a hearing, that's fine. Just cite some fucking law. I will also take a moment here to point out that when, I think it was last year, Indiana executed the first person they had executed in a long time. And it was a guy that had murdered, I don't know, I think 4 or 5 people. And his case went, and this was before Judge Gull. And it went up, and she gave him the death penalty because it was death penalty eligible. And so that's, within her, think whatever you want. I got heavy opinions on that. But that case was taken up to the Indiana Supreme Court, and it was sent back down with a note from the Supreme Court to Judge Gull, citing some of her statements in the sentencing that were inappropriate to they were, I don't know if it was inappropriate. I'll have to find it, but it was something about it being irrelevant or not taking into account the actual balancing of mitigating versus aggravating into the sentencing, but also was basically threadbare. And so the Supreme Court sent that death penalty case back to her, not because of the judgment, but because she couldn't fucking be asked, couldn't be arsed to appropriately cite enough and proper law. That if you're going to put a guy to death, at least, I mean, I couldn't fucking believe it when I read that. I mean, whatever, I could, but yeah, it was let's see. State's response also varies. Finally, the one affidavit the state did submit supports this. In response alleges facts Mr. McClellan knew or should have known are not true. For all these reasons, the court should order the state's response stricken from the record. Conclusion. The foregoing reasons, Mr. Allen respectfully requests court strike state's response from the record of this case and either vacate Mr. Allen's convictions or set a motion to correct error for a hearing. Mr. Allen also requests any other appropriate relief respectfully submitted. Mr. Baldwin. So, thoughts? Anybody? Everybody? All the bodies? Yeah. Yeah. So, listen, I don't know. Does anybody know? Is there this case? It's just right. It's just. Anybody? Thoughts? I mean, I think that this has been posted for everyone to go and read. I just, yeah, it's just, I don't know. I think, again, objectively, just looking at what McClellan filed, it just, it's it's disrespectful, frankly. I mean, to the families, to Mr. Allen, to the state, to the bar. I mean, I may be going a little over the top here, folks, but Nick McClellan is a public servant. And he is not following the very clear rules that have been laid down. And we aren't even this doesn't even get into I mean, this has, the arguments about the substantive facts and then the contradictions. At some point, all of this, I'll say this. Coincidence after coincidence, bad filing after bad filing, sloppiness after sloppiness, small town this, small town that. You can't have it all. You can't say that all of this is a mistake. That, there are. I mean, shit. The defense should, I mean, it's just about sloppiness and I mean, I don't know. But my mom told me when I was a kid that, the reason she doesn't lie, in addition to, lying being just wrong, is that, and I'm sure you all heard this before, she didn't lie because she couldn't keep her lies straight. She doesn't do it, which is why I don't do it. If I'm wrong, I say I'm wrong when I find out. But this reads, the state's response, and then this from the defense is about, I'm not saying they're lying. What I am saying is that they sure as shit aren't being forthcoming. But it smacks of a person that cannot keep their story straight because of the lies that have been told. That's what it feels like. It feels like that to me. Now, I hope we know that I mean, I don't know what Judge Gold is going to do. I mean, everybody has their opinions, but I really do hope, honestly, just for the sake of transparency at this point, that they have a hearing because again, this matters. This matters. And it's serious. And people that try to say that the defense is being unserious are blowing smoke up your anus. They just are. Oh, wait, past your bedtime. Passenger 33, where are you from? Criminality tonight. Oh, another crank. So yeah, I am like, y'alls. Anybody? I don't know. I've got nothing really to offer except for just being real grumpy. One of the things that I do want to point out, though, from Mr. Lesenby's interview with Murder Sheet. Oh, third shift, Evansville, Indiana. Okay. All right. Well, have a good nighty night. Get some sleep. Um, let's see here. So this is the Delphi murders. First person Chief Deputy Tobe Lesenby. Transcript from the murder sheet. Let's see. Where does he say it? He says in here, and I'm not putting this up on screen just because I'm too lazy. What's your impression of Nick McClelland? This is the softball questions that Tobe's getting from Murder Sheet. Just very, very impressed. Nick, I think he alluded to this at the news conference and has before. He claims from the world of being a defense attorney when he first started his career. So, that's that love-hate relationship between defense attorneys and law enforcement. What the fuck are you talking about? Why is this the narrative? That exists in your little brain, Tobe. I hate that. Jesus Christ. And that's just such bullshit. And that's why I think it's just so unfair what Murder Sheet and, prosecutors or whoever the fuck is covering this, as if they have some sort of moral authority because they have a law degree with such just disregard for how the criminal legal system actually works and how there's collegiality, especially in small communities, between defense, prosecution, and law enforcement. I said it, say it again. I grew up on a farm in Iowa in the middle of fucking nowhere. Let me tell you something. Lawyers, I mean, my dentist, his son ended up going on to be one of my divorce attorneys. County prosecutor was the sheriff, everybody. There's no love-hate. There is, and anybody that tries to sell you that bullshit is selling you bullshit. Or they got an axe to grind. Or they just protest too much, because that was not my experience in Iowa. And let me tell you something, Indiana, Delphi's a big ass town compared to where I'm from originally. I don't know, maybe Delphi, you big city folks do shit differently, but that's not how we country mice did shit. So I don't know what the fuck that's all about. Actually, I do. It's erecting that wall that says that it's us against them versus it's getting to truth and the best justice that we can. Also, Tobe says in his interview that he prefers when talking to people or when getting information to go straight, get it straight from the horse's mouth. I've reached out to Mr. Lesenby in hopes to hear from the horse. Will I? Probably not. They don't want to talk to anybody else but the definitive reporters on Delphi, right? It's nuts. So, all right, I gotta go. But I was gonna do something later, but now I'm not. It was just shit. Timeline issues, uh, letters to inmates, things like that. Um, but anywho, well, and this is a good point. So IndyStar has never been terribly interested. I made touch with well, I'm trying to make touch with somebody in the IndyStar. Um, and just got, I mean, just uh, I'm just in the very beginning stages of that because I think it's important. I think that IndyStar does have an investigative unit, and they really could bring value here. Um, I wish they would. But anyway, all right, so that's it. Uh, and I'm just, you know, thanks. Thanks for being you. Um, be all you can be. Um, smell you later. And if you are the kind that celebrates the holiday, go ahead and, celebrate the old holiday. It's my niece's birthday. Happy birthday, my Squidward. And okay, so thanks, you guys. I really do appreciate it. And yeah, smell you later.